Welcome back to another jaw-dropping courtroom moment. Today, we're watching the case of Levatne Cedric Shannon, a repeat OWI offender caught in front of a very unimpressed judge. The stakes? Huge. Shannon's blood alcohol content was recorded at 0.188 on his third OWI. And despite treatment claims, the prosecution is pointing out a trail of missed and failed tests. Now here's where things get messy. Shannon insists he's innocent of drinking alcohol, blaming his positive results on so-called non-alcoholic beers. But as you'll see, the judge isn't buying this explanation for a second. This case is the perfect storm. A frustrated defendant, a skeptical judge, and a courtroom balancing patience with punishment. Stick around because what the judge tells him near the end will leave you stunned. But first, let's break down how Shannon tries to defend himself and whether it holds any water at all.
Mr. Simpson,
You can shake your head all you want. You're lying to me. You're shading the truth. 6 p.m. today. Do you understand me? I'm done talking to you.
Yes. Defender Hannah Apple appearing on behalf of Mr. Shannon. Mr. Shannon, will you state your name for the record?
Levatne Shannon, Levatne Cedric Shannon.
Okay. What are we doing today?
Your Honor, today's date and time, we are asking for an adjournment. Mr. Shannon completed an inpatient treatment recently, so I'm asking for documentation from him so that we can further discuss negotiation with the prosecutor's office.
And Your Honor, before we set a date, I did want to make the court that he's had multiple missed tests as well as positive tests from August 12th until September 10th. Which is very concerning to the people given that this is an OWI third in which the BAC was 0.188 and he's had numerous previous OWIs.
And also, just so that you know, he's probably going to repeat what he put in the chat, which he probably shouldn't have put in the chat.
I saw that, Your Honor.
Yeah.
Can I say one thing?
I saw the distress on your face.
Yeah.
Mr. Shannon?
I had no idea because the scrambler, it was non-alcoholic beer. That's what it said, non-alcoholic. So I'm on naltrexone. I can't, this right here is a blocker. You can't get drunk on it. So I was just drinking for the beer. I was, we were barbecuing and things like of that nature. And I was just only drinking for the beer.
Your Honor, you
might want to jump in here, Miss Apple.
Yes, Your Honor. So the information Shannon did put in the chat, Your Honor, I would ask for some consideration considering this confusion on it. Mr. Shannon.
Confusion on what?
I didn't know that non-alcoholic beer contained alcohol. I was on the scrambler and it never came up.
Mr. Shannon.
Huh?
Your Honor, it would be concerning as when he did test positive, he was at a 0.027, 0.021, 0.020, 0.016, and so on.
If the court would allow Mr. Shannon one final opportunity, he would report for a
Should you agree?
to prove to the court.
I threw it all out.
Yeah, I request on behalf of my client one final opportunity now that it is very clear that he is not to consume even non-alcoholic beer as there may be alcohol in it and be placed on a scram tether. And that I can get the documentation regarding the treatment program. He did inform me that he completed a 30-day in treatment at Brighton Recovery Center and provide that to the court and to the prosecution.
Oh, I need a copy of the report because I don't have the report from Community Corrections. This is one of those times that maybe if the client hadn't started talking, you'd get your wish, Miss Apple, but I don't think so. So what I'm going to do is I'm going to pass the matter. Can prosecutor or the public defender send to Miss Weidling a copy of his report, and then I'll call his case back up. We'll deal with this bond issue in the adjournment. I'm looking at this bond violation report, and my concern is we get to September 8th. When he blows an 021, an 020, and a 0.16. Then on the 10th, he blows an 041, and then subsequent tests for alcohol thereafter showing that. And then later on the 10th, he missed a scheduled retest, but then later on the 10th, he's blowing numbers. Now, am I to understand that all of that is from Bud Zero? Is that the defendant? Hold it. Oh, whoa. And Mr. Shannon, let me just tell you, been doing this a long time, so you might want to think before you start answering me.
Okay.
Am I to understand that all of that's from Bud Zero?
Some of it's from O'Doul's, Bud Zero. I drink Heineken Zero, but I'm on naltrexone. So even if I was drinking alcoholic beverages, it wouldn't, you know what I mean? So it would defeat the purpose. I was just drinking because I'm around people that drink.
I didn't ask you all that.
Yeah. Well, yes, it is.
And you're saying it's from O'Doul's, Bud Zero, and what else?
And what? O'Doul's, sometimes it's Heineken Zeros. I drink a ton of them. And I didn't know because when I was on the scrambler, it never appeared. It never showed dirty. It never showed dirty. It only shows dirty on this machine. This machine is super sensitive. I didn't know it. I didn't understand the technology.
Mr. Shannon?
Yes, sir. Yes, sir, Your Honor.
You blew an 06, a .06.
Yeah, and I looked it up on the website. After I talked to my attorney, Miss Apple, I looked it up.
Okay, so Mr. Shannon,
Yeah.
I'm going to stop you right now because you already may have talked yourself into jail, but you're not helping yourself.
Okay.
At all.
Okay.
But I'm going to give you an opportunity at least to speak with your client. I'm going to adjourn this matter to our 3:00 block with the bond hearings. I might suggest to you that between now and then that you get whatever affairs you need to get in order.
Okay.
The first thing you probably ought to get in order, and you can have that conversation with Ms. Apple, is you might want to get your story in order to me. I don't, I realize people mess up. I get it.
Sure.
But the thing I hate more than that is when people lie to me.
I understand that.
I'm going to leave it right there. We'll see you at 3:00.
Levatne Shannon, can you hear me?
Yes, I can hear you.
Okay.
All right. This was originally set, and I had indicated that Mr. Shannon needed to come in person, but I think there may have been some transportation issues, which he won't have until 4:30. At least we are informed. So I've allowed him to appear for the purposes of this hearing via Zoom.
Good.
All right. So go ahead. I'm sorry, Miss Apple.
No, I didn't apologize for interrupting, but I want to thank the court for allowing that. Mr. Shannon is currently in Detroit, so he informed me that he would not have transportation until 4:30 today. So I do appreciate the court's courtesy in that. Have an opportunity to speak to Mr. Shannon after the previous court hearing and was able to get some additional information from him. He would admit today to the violation. He informed me that he was consuming 20 to 30 beers a day of the O'Doul's, which contain 0.5% AV. And so he would admit to consuming that alcohol and understands that that is a violation of his bond, which resulted in multiple positive tests at this time.
Okay. Let me just say this, because it is about a 10 to 12 can ratio of the non-alcoholic to the alcoholic beer. Problem with that whole analysis is while he may have been consuming that amount, and I'm not going to go into great detail on this, because of the elimination rate of a human being, for him to get that level, he would have had to consume those 10 to 12 in the time it would have taken to do one beer. Yeah, I don't think that happened. That's a lot. But I'll accept the admission to the violation. While I still don't believe that what he's indicating in terms of how that happened, but I'll accept the admission to the violation. Did we set a new date on this yet? No. What I will do is well, Ms. Apple, what were the parties intending on doing with this case?
Your Honor, I was seeking an adjournment to get some documentation of treatment that Mr. Shannon completed in discussion of potential resolution or waiving this matter to circuit court.
All right. Well, Mr. Shannon, anything you want to do before I sentence you on the violation?
No, sir. Just that if I get sentenced to some time, I would turn myself in Monday or Sunday night.
Well, I'm going to order that the defendant, before I sentence him on the violation, the defendant, you're to surrender to the Washtenaw County Jail by 6 p.m. this evening. Or a bench warrant will issue for your arrest with no bond.
Okay. Would it be okay with you if I did it Sunday night though? Because I just got one.
No, sir. No, Mr. Shannon, I don't have a problem giving people some leeway.
And that's what I'm asking for. I got something really important I got to do tomorrow.
Mr. Shannon, I'm going to advise you to let the judge finish his direction.
I don't mind, and I'll just say this, Mr. Shannon. I told you that I get people that they slip up. I get that things happen. Exactly. And I'll be able to deal with people when that does. Mm-hmm. But what I don't like is when something happens and people are lying to me. I think you were lying to me when you were first here. Yeah. I think that then through your counsel, but I mean, I understand she's advocating for you. Mm-hmm. I don't think you're telling the whole truth in terms of your consumption of alcohol. You could not put 20 to 30 beers in the time it takes for one beer to get into your system because your body can't hold it, and then you're going to be eliminating that alcohol that you're putting in. It doesn't make any sense. Mr. Simpson, you can shake your head all you want. You're lying to me. You're shading the truth. 6 p.m. today. Do you understand me? I'm done talking to you. Or a bench warrant will issue without bond. Miss Apple, would you like me to then set this for next week or 2 weeks out?
Your Honor, if it could be set for next week, please. Thank you.
Next week. I'll set probable cause conference September 21st, 9 a.m.
And there it is. The judge lays it down. Surrender by 6 p.m. tonight or face immediate arrest with no bond. After a string of failed tests, unbelievable excuses, and a desperate attempt to spin his way out, Shannon is out of time and out of options. This moment highlights something powerful about courtroom justice. Judges may forgive mistakes, but lying and dodging the truth will only dig a deeper hole. Shannon's insistence that non-alcoholic beer caused multiple high readings just didn't pass the smell test, and the judge made that crystal clear. Now here's the question for you. Do you think the judge was too harsh, or did Shannon get exactly what he deserved? Drop your thoughts in the comments. I'd love to hear your take. And if you found this breakdown as shocking as we did, make sure to hit that like button, share this video, and subscribe for more intense courtroom showdowns. You won't want to miss what's coming next.